Next matter. Next matter.
Not 1 week time may be granted. I was just seeking one.
It's difficult for us. It's a 136 petition to reappeal.
Not the medical evidence which was examined by the doctor. He has not been able to. That's why the injury report. We wish to bring the injury report. He examined the victim after 2 months of.
The injured stepped into the box. Yes. The injured said this man was the assailant and the co-accused was the person who had caught hold of me. Right? 8 stab injuries. 8 eyewitnesses.
No eyewitnesses, my lords. No eyewitnesses. No one was present at the moment.
You don't need an eyewitness. The injured himself is an eyewitness.
The victim was examined after 2 months. So just the record may be brought on 2 weeks time may be granted.
Sorry, ma'am. Sorry. Thank you. Next matter.
Please. My fundamental submission, Millard, is that section 9M will not be applicable, Millard, in this case because the victim is more than 12 years, Millard. This is my submission, Millard. For that, Millard, Lordship may kindly come to the interview order, Millard, page number 4, Millard, 2.4, Millard. There was a ossification test has been done. There is a birth certificate. So they have made, it was marked through PW2, the investigation officer. No one was examined, even the authorities or from the school, Millard, no one was examined. Lordship may kindly come to, Millard, page number 4, 2.4, Millard, paragraph. This is High Court, Millard. I will show from the trial court also, Millard. Then I will show the evidence, Millard. Then I will come to the findings, Millard.
Sentence?
Sentence 5 years, Millard.
For the offence under?
7, 8, 9M, Redwick 10, Millard.
What about the other offences?
This is the entire stretch, Millard. 7 is the aggravated, then that means the normal, Millard. Then 9M is the aggravated one. Then therefore, Millard, the conviction is under 8 itself, 9M itself, Millard. There is a conviction under 10, Millard.
Gross facts. Very, very gross facts.
So, Millard, I am not saying so, Millard. The only thing is, Millard, I am regarding that saying I am not arguing for acquittal, Millard. I am saying that the 9M is not applicable, Millard.
That's your argument.
Yes, Millard.
But the finding is that the victim was 10 years of age.
Therefore, Millard, I want to show from the documents, Millard. It says 11 to 13, Millard. Not to chase, Millard. End of the site to higher, Millard.
Dismissed. Next matter.
Millard, I have not shown any documents, Millard. What is the finding of it, Millard?
Sorry. Next.
But here it says, Millard,
that
certificate was not true, Millard.
It's all right.
Right.
This case, Court of the High Court suffers from 2 errors. Firstly, the first applicant had not considered either the nature of offence or the character of the accused. This is a crime against women. I had filed a revision even for enhancement of sentence. That aspect has not at all been considered. And then, my lords, the High Court, relying upon a case relating to 307, has gone on to hold that was a worse case.
Matrimonial problem.
Matrimonial.
Dismissed. Next matter.
My lords,
The next matter.
present.
Nice.
Yes.
Well, in the instant case, my appeal was dismissed by a cryptic paragraph. Only suspension of sentence was listed. No evidence was present. Records were not called. The paper books were not perused. My lord, I take my lordship to page 3 of the impugned order. Page 3, my lord. Paragraph 6. Is my lordship with me, my lord? Therefore, may I read, my lord? Therefore, the petitioner has committed a very serious and heinous offence as against a 6-year-old minor child. This court finds no infirmity, illegality in order passed by the learned trial court. This is the only reasoning, my lord. In fact, my lord, I would like to rely upon the dictum of this court, where this court held, my lord, as regards an appeal, it's a substantive right. And
where is the order framing charge annexure?
My lord, framing of charge is not brought on record, my lord. The charge sheet is there at 83.
Okay, let us see the offences in the FIR.
My lord, at page 28 to 32, my lord.
Where do we find it?
Page 28, my lord. The FIR.
But where is the column of offences? Section?
My lord, 5M and 6 of POSCO Act.
Okay. Take us to the operative part of the trial court's judgment. Annexure. Annexure
Annexure A3, my lord,
A3.
at page 39. It starts from page 39.
Just a minute. So let us see the operative part.
At page 39, my lord, the charge 1 and charge 2 is extracted. At page 41, my lordship may find the judgment.
Conviction is for what offense?
For 376 AB.
376 AB.
Yes, my lord, not under POSCO.
And what is the sentence?
20 years, my lord.
20 years. देंगे?
May I be permitted to circulate judgment also, my lord? You can.
Paragraphs, the appeal is dismissed.
Yes, my lord. No consideration at all. In fact, my lord, only suspension was listed. The evidence were also not called. Records were not called. Paper books were not perused. Was not even.
Only one accused?
Yes, my lord.
You are the tuition teacher,
Yes, my lord. Alleged.
dance teacher.
Yes.
Take down. The petitioner was put to trial in the court of was put to trial in the Mahila court, Tiruchirappalli, state of state of Tamil Nadu, in special sessions case number 40 of 2019 for the offence punishable under section 376A(b) of the Indian Penal Code, or short the IPC, and section 5(m), right?
Yes.
Read with
Section 6.
section 6 of the Protection of Children from Sexual Offences Act 2012, or short the POCSO. The prosecution examined 14 witnesses in the course of the trial. Good point. The petitioner herein, at the relevant point of time, was a dance teacher, and the victim was her student.
Yes.
Student. Full point. At the end of the trial court held the petitioner guilty of the offence punishable under section 376A(b) of the IPC and sentenced him to undergo 20 years of rigorous imprisonment with fine. What happened in POCSO?
My lord, he was empty.
The petitioner also stood convicted for the offence punishable under section 6.
What was sentenced on
The POCSO, but ultimately was sentenced under section 376A(b) of the IPC.
If I may, my lord. My lord, it says when the above mentioned incident took place, section 6 was not brought into force by the amendment. but section AB of the penal code was in force. Hence only section 376 AB.
No, section 42 would be relevant because section 42 says
Yes,
if the punishment under the IPC is greater
Yes, my lord.
than that under the POXO, then he will be punished under the IPC.
Yes, my lord.
It is for that reason he was punished under IPC.
Yes, my lord.
The petitioner, being dissatisfied with the judgment and order of conviction passed by the trial court, went in appeal before the High Court. The High Court dismissed the appeal. We did the impugned judgment dated 24/2/2022. In such circumstances, referred to above, the petitioner is here before this court with the present appeal. Next. We take notice of the fact that the impugned judgment of the High Court is a non-speaking order. The entire appeal came to be disposed of in 6 paragraphs. We find no discussion of the evidence led by the prosecution by the High Court worth its name. Purport. Next, issue notice, returnable answer incident. It shall be open for learned counsel to serve a copy of his SLP to the standing counsel appearing for the state of Tamil Nadu.
Obliged. May I request a specific date, my lord? Subject to my lordship.
That will be given.
Obliged.
There is a delay of about 49 days, my lord. The parties were married in 94, my lord, and they were separated in year 2011. And we had 2 children and they have become major also, my lord. There are some subsequent developments in this matter, my lord. 2 years back, I came to know the respondent is married, and even my son got married, and if criminal case was filed against my son and my wife also, under 498A by my sister, Bohu.
What is this impugned order?
No, the impugned order says because before the trial court and the appellate court, the maintenance was not given to the wife because she was earning a debt chum as a beauty parlor.
Why should we interfere?
No, only because of the subsequent development. What has happened is because I came to know that she's married again.
Doesn't matter.
No, and then subsequently what has happened, even my son got married and they are living together. I have to clear off everything. No, a 498 case is filed against my son and my wife also again by the new bohu. Well, I want to get the matter settled. I'm 56 years, my lord.
Against.
Both the time that she is earning.
The impugned order is dated 29th of April 2024. And according to you, the lady got remarried on which date?
No, that we are not sure because in the wedding card of my son, a new person's name was there. And in 2024,
Now, what do you want to argue before election?
no, we want is let the matter be referred to a mediation center. Because 2013 is the High Court matter. The subsequent developments were not brought to the knowledge of the High Court.
If you read 127
To
of
apply under 120.
Then you also may give an observation.
the petition is not pressed with liberty to avail appropriate legal remedy before the appropriate forum in accordance with law, including filing of an application under section 127 of the CRPC, if maintainable in law.
Public.
Right, please, Because my IA for suspension of sentence has been rejected. I've undergone more than 5 years, 8 months out of the 15-year imprisonment. The defense was that the car which is being seized, I had already sold it. And I was arrested. That was my defense version.
You want suspension of
Yes,
sentence.
yes.
Therefore, you need to point out something glaring on the basis of which you can argue that on this point I am 100% going to succeed in appeal. If my appeal is ultimately going to be allowed, What is the point in keeping him behind bars?
Lordship.
Point out that glaring thing.
Because as far as that aspect is concerned, my version has been that I was the car which was produced or which was seized along with the narcotics minutes. I had already sold it. The person whom I had sold, so I was not arrested with the car.
That's the question of your question of fact.
Yes, Milord.
You'll have to look into the
Yes.
evidence.
And Milord, that learned trial court, Milord.
Why the conviction is erroneous.
Yes, Milord. Milord, as far as this aspect, Milord, if I am not there.
Appeal is of which year?
Milord, appeal has just been filed. Milord, I have been inside jail during the course of the trial, Milord. It is a 2024 appeal itself, Milord. And Milord, it will take some time.
Okay, issue notice.
Lordship, please.
No evidence has to obvious, Your Honor.
Case the petitioner has been convicted. B2C of the NDPS Act and is sentenced to 15 years. Now, the only point that I am agitating before your lordship is, it is an admitted case that when the police officer found the narcotic substance, there were 73 packets. The total quantity was 150 kg. He has done sampling on his own, your lordship. So there is a clear violation of section 52A of the NDPS Act, which says that the sampling has to be done in presence of magistrate. Now, what is the sentence? The sentence awarded is 15 years, your lordship, and he has undergone 6 years, your lordship, almost 6 years, as per the custody certificate. To notice. Your lordship, I may be permitted to serve this time.
Yes.
I'm deeply obliged.
No pass. What is the matter?
This is a conviction in a 302 matter, my lord.
Yes.
Conviction has been upheld. There are inherent contradictions in the witness testimony, my lord, including the medical examiner's report itself. My lord. Because the medical examiner, the doctor's statement categorically states the allegation against me is that I was sitting in the car in the back seat and had shot the deceased, my lord. Now the doctor in his cross has categorically stated that the gunshot is not of such
Issue notice.
Great. Not on interim as well. Private banking?
You want interim relief?
No, notice on interim as well.
Why? Want relief 2 weeks.
Because he's been in jail for 12 years now.
You have been in jail for 12 years.
12 years.
This is
18 months.
18. The petitioner was convicted by the trial court for the offense punishable under section
30.
18.
18.
From where do we get this POXO and all?
That bench, the court is. That's the difficulty.
But it was 302.
302. Yes.
क्या लिखा? The petitioner stood convicted for the offense punishable under section 302 of the IPC
And 27(2) of the arms.
and section 27(2) of the Arms Act. So what? He was sentenced to undergo life imprisonment. He preferred criminal appeal number 33338 of 2018 before the High Court of Telangana.
Page 55. So live.
The High Court also thought fit to dismiss the appeal. However, has been noted by the High Court in para 11 of the appeal judgment. Both this para 11 and page 11. Right? Next. We have heard Mr. So-and-so, the learned counsel appearing for the petitioner. He submitted that the petitioner has undergone almost 12 years of sentence so far. The leave granted. Having regard to what has been observed aforesaid, we suspend the substantive order of sentence of life imprisonment as imposed by the trial court and affirmed by the High Court, and order that the appellant be released on bail pending the final disposal of this appeal, subject to terms and conditions that the trial court may deem fit to impose. Next matter. Referent. Yes.
Your Lordship, this is regarding the quashing of FIR along with the final report that is submitted by the police, Your Lordship. The issue here was, Your Lordship, there were allegations of 498A and other allegations, Your Lordship.
So sister-in-law quashed.
Parents and sister-in-law quashed, Your Lordship.
Parents and sister-in-law quashed.
Yes, Your Lordship.
Husband has to face the music.
Yes, Your Lordship.
And what is that criminal case number? Criminal case number?
Of the criminal case number.
Give us the criminal case number now. Oh Lord.
Just page 80.
Charge sheet filed.
Yes, Your Lordship.
So once the charge sheet is filed
Yes, Your Lordship.
and the magistrate takes cognizance,
Yes, sir.
it culminates in some criminal case number, right?
Yes.
What is that criminal case?